Oh yeah, Bill's on the other side now. Got it.
Oh, okay, that's okay.
It is interesting, huh? So she's
All right, it's 1 p.m. Thank you for coming back. Okay, so we're going to start shortly now with Mr. Luis Carrasco, who will give you a presentation on the Open Meetings Act. But before I proceed, I just wanted to thank the Valencia
County News Bulletin.
County News Bulletin. Anybody
All right,
here?
thank you.
Thank you.
They suggested this awesome space and asked us to come here, so thank you.
It's beautiful. Thank you very much for accommodating us, and I'm sure we'll be back in the next couple of years. And so I give you Luis.
So I'm going to obviously talk to you a little bit. Can you hear me? Do I need to use the mic? Is that better?
Oh, yeah.
Okay. I'm going to talk to you a little bit and walk you through the mechanics and the nuances of the Open Meetings Act over the next hour and a half. I don't mind if there are questions intermittently throughout the presentation, so if something pops into your mind, please just raise your hand and let me know. But I have built in some question and answer time into the later portion of the presentation, so if you prefer to do it that way as well, that's fine. I tend to be a little long-winded when it comes to talking about the OMA. I'm a really weird person. I'm really excited about the Open Meetings Act. I know a lot of you may not share that enthusiasm, and that's okay. So to the extent that you can keep your questions to that portion, that'll help me keep me on task and not talk your ear off. So that would be good. As Mona said, my name is Luis Carrasco. I'm an Assistant Attorney General in the Open Government Division in the Santa Fe office of the Attorney General's office. I've been an Assistant Attorney General for about 3 years, but before law school, I worked in the Open Government Division as well for about 5 years. So I've been dealing with open government issues, Open Meetings Act, Inspection of Public Records Act for about a decade now. So not only is it a passion of mine, but I do have some experience that I hope to be able to impart to you. So I wanted to give you a little bit of an overview about what we'll be talking today before we get started. First, I'd like to start off by just a brief discussion of the public policy underlying the Open Meetings Act. Why do we need an Open Meetings Act? What was the legislature contemplating when they imposed these requirements on public bodies? Because I think that lends some real insight into why the procedures for noticing meetings, the requirements, agenda, meeting notices, and minutes, why they're in place, and what purpose we're trying to achieve by enacting an Open Meetings Act. We'll talk about some of the requirements under the Act. This is the mechanics, the nuts and bolts about how you go about noticing a meeting, how you go about posting an agenda for a meeting, how deliberations in a meeting are to occur, and how you close a meeting. So I'll walk you through how to do all of those things properly. Then we'll talk about the exceptions to the Act. Very similarly to the Inspection of Public Records Act, there are certain items of discussion that the legislature has said public bodies can go behind closed doors to discuss. And we'll talk about what each of those are. I'll probably skip over a few of those because they're not relevant to anybody but very limited constituencies, but I'll identify those for you. I'll talk a little bit about enforcement of the Act. Like IFRA, the Attorney General's office has statewide enforcement over compliance issues. And as an exercise of our enforcement authority, we come out into communities very much like we're doing today to educate public officials and members of the public about the intricacies of the Open Meetings Act. Talk a little bit about consequences for violating the Act. You heard Mona say there were no criminal penalties associated with violations for the Inspection of Public Records Act, but very differently, for OMA, there are criminal penalties for violating the Open Meetings Act. So I'll go over that a little bit with you. And then just a few tips. These are sort of more nuanced issues that you can't really extract from just reading the text of the Open Meetings Act alone, but after having reviewed complaints and dealt with public bodies and Open Meetings Act compliance, these are a little bit of, I hope, tidbits of knowledge that I hope to share with you to avoid open meetings problems in your governing bodies. And then I'll share with you some resources that are available to you to help ensure that your public body is comporting with the Open Meetings Act. So moving right along to the public policy underlying the OMA. Why do we need an OMA? What was the legislature's thought back in 1974 when they said we need to subject public bodies to these requirements to conduct their business and deliberations in the view of the public? And very wisely, I think, the legislature tells us exactly what they were thinking in the very first provision of the Open Meetings Act. It's 1015(1)(a). And they tell us that they recognize that an informed electorate representative government like ours, our democracy, is dependent upon an informed electorate. And how do you go about getting an informed electorate? You open up public proceedings to the public. You make records available for inspection so that members can gather that information, make educated decisions about who they're going to vote for to elect to public office, what policies are being articulated by these public bodies, whether they're in agreement or not, and conduct themselves in our democratic system accordingly. And the only way they can do that is by being afforded access to public deliberations, public records, matters of public import. And that's the very vital role that the Open Meetings Act plays. The legislature tells us explicitly that the public is entitled, it's not a privilege, they have the right to the greatest possible information about governmental affairs and the official acts of public officers and employees. So we shouldn't view it as a hindrance from the perspective of public officials, these arbitrary and unnecessary regulations. This is a right that has been afforded to the public, the citizens of New Mexico and all persons really. And in complying with the Open Meetings Act, we're making sure that they get what their right is. The legislature has also told us that formation of public policy and the conduct of business by vote shall not occur in closed meetings. And you'll see this recurrent throughout the presentation. When a public body is formulating policy or taking final action, that will always be in an open meeting. We'll talk about circumstances where discussions can go on in private, but you'll again and again see action, taking final action and formulating policy has to be in a public meeting in full view of the public so that the public has that access and information about what their government is up to. The legislature also tells us that all meetings of a public body shall be public meetings and any person so desiring shall be permitted to attend and listen to the deliberations and the proceedings. I like to point this out there because you'll note that the right that's afforded is this greatest possible information, but particularly with respect to open meetings, the public's right is to attend and listen. You'll note that it doesn't necessarily say a right to participate. You'll be afforded access and you can hear the deliberations of the public body, but that's as far as the Open Meetings Act goes. As of yet, there have been some efforts to broaden that a little bit, but not successfully yet. And in the very first section, this is something that's become a little bit of an issue as of late. The legislature explicitly requires that public bodies make reasonable efforts to accommodate the use of audio and video recording equipment in public meetings. Now that doesn't mean that it always is required to allow video recording. You don't have an obligation to allow video or audio recording that gets disruptive. It's just out of hand. It doesn't allow the public body to go on with its business. But to the extent that people are acting properly and not disrupting the proceedings, there's nothing wrong with bringing in your cell phone and recording a public meeting. So we'll move on to talk about when does the Open Meetings Act apply. The Open Meetings Act will not apply to every meeting of every governmental official in the state of New Mexico. It applies in very specific circumstances. And one example I like to highlight is if you say I'm the cabinet secretary for some state agency in New Mexico, the legislature has vested in me authority to make decisions and policy determinations in and of my own authority as in that office. I'm acting as an individual person. The legislature has given me that act. I don't have to open up all my deliberations and, meeting time in my office to the public scrutiny. I exercise that authority as my own right. The Open Meetings Act will apply when public policy making or decision making authority is given to a group of people when they're acting collectively as a public body. So a board, for example, a board of county commissioners, where you're not exercising authority in your own right, but you're acting as a group and acting as a whole. So 1015(1)B tells us exactly when the Open Meetings Act will apply. It says all meetings of a quorum, that's a key term, quorum of members of any board, commission, administrative adjudicatory body, or other policy-making body of any state agency, or any agency or authority of any county, municipality, district, or political subdivision. It's pretty broad reach. So if you're a collective decision-making body of the state or political subdivision, county, municipality, more than likely the Open Meetings Act is going to apply to you, to a quorum of that body. So half plus one of the body. And sure.
Question. Would this also apply for utility companies that are privately owned?
It has to be a public entity. So if it's a private entity, the Open Meetings Act will apply. This only applies to public bodies.
Okay, so but it can be other than governmental?
Usually, no, it's public government entities. If it's a public board, commission, administrative, something that has authority to formulate public policy beyond just the scope of, you know, the administration of a business, perhaps. So when you have a quorum of one of these public bodies that's convened to do one of three things, the Open Meetings Act will apply, and you'll see this underlined in, I guess it's orange on this display. Held for the purpose of formulating public policy, we sort of talked about that already. So if you've got a quorum of a public body meeting to formulate public policy, to promulgate regulations, to adjudicate a particular case that's come before it, the Open Meetings Act will apply. Or if you've got a quorum of a public body who's met to take any action within its authority. We're taking a vote on revoking somebody's professional member's license, for instance, and that authority is vested in that public body, and you're needing to do that, the Open Meetings Act will apply. And finally, you'll notice here, discussing public business, it's actually the second one. So even just discussions where you're not going to take any action within your authority or formulate public policy, the collective body is meeting to discuss matters of import to that body. The Open Meetings Act will apply then as well. And there's a little section here in the last part of the orange section there, or exercising the delegated authority of any board. I'm going to talk a little bit about that later too, but what does that mean? That means when the collective body has said, we have this authority, but we're going to give it to somebody else. And there will be instances where that delegation will carry with it the requirements to comport with the requirements of the Open Meetings Act to provide meeting notices, agendas, and minutes. So all of those meetings that we just talked about are declared to be public meetings open to the public at all times. So anytime they're doing that, it'll be subject to the Open Meetings Act, except as otherwise provided in the Open Meetings Act or the Constitution of New Mexico. So your general rule shall be, if we're meeting to do any of these things, it's got to be open to the public, we've got to notice it, we've got to provide an agenda, we've got to provide minutes. We'll talk about the 10 instances when those requirements don't apply. Did you have a question? Okay.
Luis, is there any requirement that notice of the meeting be made public?
Yes, and we're going to talk exactly about that right now. Good segue. So, Open Meetings Act requirements, and these are spelled out in 1015(1)D. These are the mechanics, if you will, the nuts and bolts of providing public notice of meetings. And there are three major requirements that the Open Meetings Act imposes. One, the requirement to provide notice of your meetings. Second, the requirement to provide an agenda for your meetings. And third, the requirement to provide minutes for your meetings. And so what the Open Meetings Act tells us is that public bodies must give reasonable notice of all meetings where public business is discussed, adopted, or formal action taken. So those things that we talked about, anytime you're doing that, you will have to provide some sort of notice to the public that you're going to meet to do those things. Any meeting where you don't provide that notice is not an open meeting. I might have a meeting and say, oh, anybody is welcome to come walk right in and listen to what we've done. That's not an open meeting. It's only an open meeting when you've actually provided whatever notice is appropriate under the circumstances, and you've given the general public an opportunity to say, oh, they're going to meet and decide whether they want to exercise their right to attend and listen. I alluded to the fact that there are instances where you can have a closed meeting to discuss public business, but even where you do that, you will always have the requirement to provide notice to the public that you're going to have a meeting that they won't have access to. That will be always something that you do. The public body must annually, under 1051D, determine what constitutes reasonable notice when applied to that body. So the legislature, in its infinite wisdom, has said, local public bodies, these counties and political subdivision and municipalities know their communities better than we do, governing from the ivory tower in Santa Fe. And we're going to leave it up to them to decide in their communities what notice is reasonable in those circumstances. And said, every year, public body, you need to come back and tell the public how you're going to provide them with notice of your meetings. And that's what we call our an open meetings resolution. And for my clients anyway, I like that to be the very first thing that we do every year. We notice an open meeting, and the very first thing on the agenda is the adoption of the open meetings resolution for 2015. And in that resolution, you spell out exactly, when we're going to have a meeting, this is how we're going to notice it. We're going to publish it in the newspaper, perhaps that's one option. We're going to post it on so many locations and at the school and at the city hall for our community. The legislature leaves it up to you generally to decide what notice is reasonable, but you have to do this every year. And under 1015(1)D, the legislature has also imposed the responsibility that if you receive a written request for notice from a newspaper of general circulation or Federal Communication Commission licensed broadcast station, you also have to provide them with notice. I've never actually seen an instance where one of them have made written notice for meetings, but if they do, you do have to comply with that, so it's important not to forget. So we'll move on to meeting agendas, and those are governed under 1015(1)F of the Open Meetings Act. And what the legislature says is that your meeting notice must include an agenda or inform the public of how they may obtain a copy of the agenda. So you've got two options. You're going to provide that notice saying at such and such time, date, and location, we're going to meet here. But in addition to that, you also have to say, here's our agenda for that meeting, or if you're not quite prepared to give an agenda, say the agenda will be available such and such date at this location, and here's how you can get a copy. So that's an integral part of your meeting notice. You need to remember to provide information about the agenda, given either the agenda or information about how they can get it. And that's left up to your public body's discretion. Secondly, the agenda must contain a list of specific items of business to be discussed or transacted. And I bring this up because oftentimes we see public bodies struggle with this a little bit, about being reasonably specific. The right of the public is to attend and listen to the deliberations of a public body. But they're not going to really know whether they want to exercise that right without being able to look at the agenda and see what they're going to be discussing or business that they'll be transacting. So you need to provide a reasonably specific description of what you're going to be doing at that meeting so the public can decide, oh, that's something I'm interested in, I do want to attend that meeting. So that's a responsibility incumbent on public officials. And sometimes they have a little bit of a difficulty being specific enough because you don't necessarily want to give too much information, but you want to provide enough information that the public body can, a member of the public can decide what they want to do. Next, the Act says that the agenda must be made available at least 72 hours in advance of the meeting, and there are only two exceptions to that. So this was an amendment in 2013 to the Open Meetings Act. Previously, the requirement to provide an agenda was 24 hours. But in 2013, the legislature changed it and said, no, you actually have to give 72 hours time between the time you publish your agenda and the open meeting. You don't have to meet this 72-hour requirement if you are experiencing emergency circumstances, which we'll describe. Or is anybody here from a public body who meets more than once per week? Okay, so that second exception only applies to those entities that meet more than once per week, so I won't discuss that in any more detail. If you have questions, you'll have my contact information and we can discuss that also later. So another amendment in 2013 that came into the Open Meetings Act was this one that says the agenda must be posted on the public body's website 72 hours in advance of the meeting if one is maintained. So if your public body does have a website, you need to make sure that your agenda is published and available to the public at least 72 hours before your meeting. If you haven't done that, that's going to be an automatic violation, and you definitely want to avoid that. And lastly, with regard to agendas, the legislature tells us that no action may be taken at a meeting unless that item appeared on a publicly available agenda 72 hours in advance. So if you didn't put something on your agenda and you get into your meeting and something's occurred, unless it's an emergency circumstance, if it didn't appear on the agenda, you're not going to be able to take action on that item. You're basically locked into whatever agenda you publish 72 hours in advance, and that's the universe of things upon which you can take action. Did you have a question back there?
You can't add a discussion item if you want to discuss it. You just can't act on it.
If you've properly noticed the meeting and told the public we're going to meet at such and such date and time, and circumstances will arise where you might need to discuss something in public. Certainly, you can talk about that. You've noticed the public that you're going to be meeting to discuss public business, but you certainly won't be allowed to take action on it. All right, so we'll move on to meeting our emergencies. Yeah. So 1015-1F also governs emergency. And the legislature tells us that when you have emergency circumstances, that may allow you to take action on an item not appearing on the agenda 72 hours in advance. That was one of the exceptions that I talked about earlier. And it gives us a standard for what is an emergency circumstance and what is not. And you'll notice that it's a relatively high standard. And I sometimes am unpopular with my clients because I feel like I have to be the guardian of this standard sometimes and say, does it meet these circumstances? If it doesn't, we need to hold ourselves to what was available to the public 72 hours in advance. But if there are these circumstances, then we can, in good faith, move forward with taking action. And the legislature tells us that an emergency equals unforeseen circumstances, so it has to be foreseen. It can't be simply a result of a lack of planning or a lack of foresight. It has to come out of nowhere. It's just a surprise. That if not addressed immediately, there has to be a requirement for immediate action by the public body will result in injury or damage to persons or property or substantial financial loss to the public body. Not necessarily substantial financial loss to another public body. It has to be substantial financial loss to your own public body. So take extra care when you're contemplating taking emergency action to make sure that the legislature has actually given you the authority to act in those circumstances. A new requirement for emergency meetings that came in 2013 as well is this one to report in writing to the Attorney General's office if you take emergency action. So if you do take action on something that wasn't on the agenda 72 hours in advance, within 10 working days you have to write to our office and tell us what you did and what the circumstances were that created the emergency. Unless there's been a declaration of a state or national emergency, that's the only time you won't have to do that. All right, so we'll talk a little bit about minutes now, and these are governed under 1015-1G. The statute requires public bodies to keep written minutes. It's not an option. In that exercise of providing the greatest possible information to the public, one way you do that is you create a record of all of the meetings that you've had. So if I wanted to learn what the village of Los Lunas was doing a year ago, I have this right to go back and look at their minutes, and I can gain that information and see, oh, what were the public policy discussions, what actions were decided. So this is one tool in giving the public that greatest possible information. And it's not optional, it's mandatory. And the legislature also tells us there are 4 things that absolutely have to be in your minutes. And if you don't include all of these things, you won't be in full compliance. Those 4 things are the date, time, and place of the meeting. I think that's pretty obvious. The second thing is the names of members in attendance and those absent. Sometimes I see public bodies forget that last piece about identifying who was absent from the meeting. So it's important to be cognizant that you have to say so-and-so were present and so-and-so were not present. Third thing is the substance of proposals considered. You'll note that it doesn't say a verbatim description or a verbatim transcript of the proceedings of the minutes. It can be a summary as long as you substantially give enough information to the public about what the deliberations were and what the decision ultimately was, which is the 4th item, record of any decisions and votes taken, showing how each member voted. You'll notice that last part. You have to show how each member voted. What does that mean? No secret ballots. There basically has to be a record of how the vote went down on each agenda item. All right, all minutes, including draft, and I included that parenthetical partly based on Mona's earlier discussion about the requirement that draft documents are subject to inspection under the Inspection of Public Records Act also. So it doesn't matter that a document is not necessarily in its final form. To the extent that it exists and you maintain it and there's a request for the record, you have to provide it, and that extends to meeting minutes as well. They're open to public inspection, but they're not official, so they remain in draft form until they've gone to the public body in an open meeting and the public body has exercised its responsibility under the same section to approve, disapprove, or amend those minutes at the next meeting, which is my last point there on the slide. And one thing that public bodies sometimes forget about is the requirement under 1015-1G that you have to prepare your draft minutes within 10 working days of the meeting. So there is a time deadline to get those draft minutes into form, and so that if you do get a request to inspect public records, you're prepared to respond appropriately. All right, I wanted to talk a little bit about remote participation, which is addressed in 1015-1C. What I'm talking about here are video conferencing. Did you have a question?
I did.
Okay.
On your previous slide. Couple of questions.
Sure.
On the, you said each member, you must show how they vote.
Mm-hmm.
In your minute meetings, you cannot put the consensus was.
There's no case law that I'm aware of that spells out you can't. Where the decision is unanimous, and I think if you indicate that there's a unanimous decision, and because of that requirement to show who was present and who was absent, if you say the vote was unanimous or whatever, you've indicated how each member has voted. It wouldn't be unanimous if somebody had cast a different ballot. But if we're somewhere there is a split vote, you'll probably want to say the vote was 3, and at a minimum identify who the dissenting voter was.
So can you use consensus, or do you want us to use unanimous?
I don't have
Either
a
one is
preference.
okay?
Yeah, I think you can probably get away with both.
Okay.
As long as a member of the public can look to those minutes and know with some degree of precision how the vote was cast, you should be in compliance.
Okay. And question number 2. Although I do this even when I do drafts, I keep the drafts. If you didn't keep the draft, once the meeting is approved, the official ones and stuff, we usually put tentative. Although sometimes I put draft as I'm drafting until I send it to the chair to do, and then I change it to tentative. I do say my draft. Then once it goes approved, that's the one we put on the website. Now sometimes we put the tentative one and then replace it with the approved.
The Open Meetings Act doesn't really speak to that, so you can do that. The thing you want to do is make sure that you have something that you can provide before the public body has actually taken action on those minutes as a draft. So a tentative version of the minutes, and I actually like the idea that you're posting even the tentative minutes to the website as part of an effort for providing the public the greatest possible information. But once the public body has taken a vote to approve those minutes, they become the official record, and any tentative drafts or tentative minutes or draft minutes aren't really going to be necessary. if there's some requirement for you to maintain them, then you should comply with that, but I don't know of anything that makes you hold on to those.
Okay. And when you talk about the 10 days draft minutes, do the draft have to be complete as a whole?
The Open Meetings Act doesn't specify that. So I think if you have, a reasonable outline of how the meeting progressed, you'll probably be in compliance. You probably want a little bit more than just the date, time, and place. You probably want some description, at least what the vote was and what the agenda item was.
Can I ask?
Sure.
On the 10 days, or they're open to public inspection on drafts, is the 10 working days apply to that? Can you tell a person that they'll be available within 10 working days?
Mm-hmm.
Okay.
If you're outside of or if 10 days have passed since the meeting, you're under that obligation to provide them. But if you're beyond that, you can say they're still being drafted. We don't have them, that's in compliance with the Inspection of Public Records Act. They don't exist yet. You can't provide them yet. So
Unless the meeting is being tape recorded, then you have something that you can provide.
that's a good point.
Do you have to post, I'm sorry, do you have to, those 10 working days, say you put a draft maybe together, maybe you just have the bullet points, maybe you haven't put the meat and potatoes all together. Do you have to post those drafts?
There's no requirement for publication of draft minutes.
Okay.
The only requirement is if you get a request to inspect them, you have to provide them.
And do these apply to USA Just and non-drafts also?
I believe that they do, yeah.
What was the question?
Whether the requirement for, the Open Meetings Act applies to acequias and land grants, and they are political subdivisions of the state and public entities, so they are subject to that. All right. And then the last thing I wanted, you have to approve, amend, or disapprove the minutes at the next meeting of a quorum or present. So a very specific time requirement as to the action on the minutes that you'll want to be cognizant of. All right, so let's talk about recessing and reconvening to a future time, which is 1051E. And this is a really helpful tool that I don't understand why public bodies don't use more, but so I wanted to call it to your attention because it can help you get out of the jam sometimes. The legislature allows a public body to recess a meeting that it's already convened and continue it at a later time. There are just some requirements that you have to satisfy before you can properly do that. So say we're in a meeting and we didn't anticipate that there would be so much public comment or such robust deliberations amongst the members of the body, and we're at midnight now. And everyone's exhausted and they want to go home, but they feel, we're only halfway down the agenda. Do we need to continue on to 5 a.m.? No, you don't. You have this tool available to you. You can say, we're going to take a break for now, but we're going to come back at a later time and take the agenda up again. So what you have to do before you do that is you have to specify the date, time, and place for the continuation of the meeting. So I'm the presiding officer. I say, we're going to take a break and we're going to come back in this very room 5 o'clock p.m. tomorrow and continue the meeting. So that's the first requirement. And then immediately after I recess that, I have to post notice of the date, time, and place for the reconvened meeting on or near the door of the original meeting place. So I'm going to draft up that notice here on my computer, and then I'm going to go out to this door right here and post notice that we're going to come back tomorrow at 5 p.m. In this room to continue the meeting. And then I have to post that same notice in at least one other location. So I go down to McDonald's across the street and I post it there. So you've met the second prong of the recess and reconvene tool.
That's not the slide.
Oh, sorry about that. There we are. That looks right. And then the only other thing to remember about recess and reconvene meetings is you're still locked into that same agenda. You can't add new things to the agenda. You're just limited to what you had, to the point where you had recessed the meeting.
If you decide to recess and do like I said, and you have to post on the outside of the door of your boardroom maybe, and you have to post it somewhere else. If you're in a building that's like 9 stories, like can you post it on the first floor?
I would encourage you to post it at a completely different location. And that goes back to this idea of providing the greatest possible information. You're only capturing one constituency, the occupants of that particular building. So putting it at another location, you'll be able to get the word out more effectively and widely.
Does that not include if you post on the outside of the door and then post it on your website? It has to be physically posted?
I don't really know, but that's a really good point. Maybe. What do you think? If they post it on the door and on the website? It doesn't say. It says one other location. Is another location the website? Maybe.
It is, but some people do not have access to the web, so I would put it.
It's a really minor thing to print 2 copies of it and go to this door and then walk to the city hall or the post office. So I'd encourage you to do that and post it to your website to provide the greatest information to the public. So I'm going to move on so that we don't run out of time. Because now we're getting to the really juicy stuff, which are the exceptions to the Open Meetings Act. And I would say, I don't know if you agree with me, Mona, but this is where public bodies sometimes have the most trouble understanding OMA, because admittedly it's pretty complicated, and you know, sometimes there are things that are uncomfortable and not necessarily, you know, dirty laundry that you don't want to air. And so there are those considerations, and there are opportunities to have these private discussions, but you have to be really careful to make sure that the circumstances you face are things that the legislature has said can happen in a closed meeting. So there are 10 things, and 10 things only, that can be discussed in an Open Meetings Act. They relate to licensing, limited personnel matters, administrative adjudicatory proceedings, personally identifiable student information, collective bargaining strategy, certain purchases exceeding $2,500, pending or threatened litigation, purchase, acquisition, or disposal of real property, water rights, strategic and long-range business plans and trade secrets, and certain gaming control board meetings. Is anyone here from the gaming control board? Okay, that's a really super specific exception, so I won't bother discussing that. It only applies to you if you serve on that particular body. All right, so let's start off with the... Oh, sure.
Before you go on, I think you skipped over the remote participation slide.
I think that's where I talked about video conferencing, and I said you had to, oh, maybe I did. Yeah, I actually did. Okay, thank you. So I'm talking about Skype, video conferencing, telephonic conferencing. That's allowed, but there are certain restrictions that the legislature has placed on that as well. And the first thing, and probably the most important thing, is it has to be, the statute itself doesn't authorize it. It gives you the option and says, here's what you got to do if you want to exercise this option. So the first thing is you have to have your own rule. Your public body has to have its own rule authorizing telephonic participation, Skype, video conferencing, or what have you. If you are a public body that has rule promulgation authority, that might be something you want to consider, is promulgating a rule saying that when we have these meetings, if the circumstances warrant, our members can participate via video conference. If there's a statute, another statute that authorizes that sort of participation, that'll count as well. And we've also, there's been discussion within our office that says even in your, we talked about the open meetings resolution, if you provided a section within that resolution that authorized its own, the public body authorized its own members to conduct that, we'll count that as valid also. So something to keep in mind. Now, there are only certain times when you can do that. Even if you have a rule, the circumstances have to warrant remote participation, because this comes from the very clear indication in 1015-1C of a legislative preference for in-person attendance by public bodies. They tell us that only when it's otherwise difficult or impossible for the member to attend the meeting in person. You'll note that it doesn't say when it's more convenient, when it's more fiscally sound, when it's just, I would rather not drive all the way to JAL for a meeting. That won't satisfy the standard. It has to be either I participate via this remote participation method or not at all. And so that you'll want to make sure that that is satisfied before you proceed any further. And there are also some more technology-related concerns that you'll have to address before you can participate telephonically as well. Each member participating remotely must be identifiable when speaking. So you need to have equipment that will allow that member's telephonic participation or remote participation to be as if they were in the room participating and everybody could hear me to the same degree as the person that's on the phone or on the video conference. So there's a modicum of a technological requirement here that you have to have sufficient technology to allow this sort of participation. The second one is all participants must be able to hear each other simultaneously. So this, you're talking about the right is to attend and listen. Only the members of the public body have the right to participate. So the members of the body who are engaging in this public deliberation have to be able to hear the person that's appearing on the telephone conference, as well as anybody else that's in the room. And the public must be able to hear any member who speaks during this meeting. This gets back to the idea of the right to attend and listen. If they can't hear somebody that's on the conference phone, they haven't been afforded that right. So you need to be very careful before engaging in remote participation. And, you know, public policy concerns. New Mexico is a huge state, and there are considerable expenses with traveling across the state for public meetings, and you know, there's also the concern that if we allow video conferencing, people from every corner of the state could just log into the computer and be able to attend to and listen to those proceedings. And there have been efforts to sort of open that up and be less restrictive, or have more of a focus on participating that way, but the law on the books still exists of this legislative preference for in-person attendance. So there have been efforts to change that legislatively. None of them have been successful as of yet, but there are certainly arguments on both sides that warrant for remote and participation and the like. So we talked about recess and reconvening exceptions, so we'll get to the licensing exception. But before we do that, I wanted to talk a little bit about the introductory description of the exceptions under the Open Meetings Act. And it tells us that the provisions of subsection A, B, and C of the Open Meetings Act do not apply to the following types of meetings. So it helps me to sort of recall what each of those sections we're talking about. So the provisions of subsection A, which dealt with the greatest possible information, the right to attend and listen, and accommodate recording and audio equipment, don't apply to these discussions that are authorized in a closed meeting. So you don't have to worry about those concerns. You also don't have to worry about the declaration of openness at all times. Obviously, if it's authorized to be discussed in a closed session, we don't need to worry about openness at all times. We have an exception that applies. And G, the minutes don't apply to properly closed meetings. So you don't need to worry about, and you shouldn't have minutes of a closed meeting, because you're probably talking about, you know, important information that probably carry with it some confidentiality concerns. So you don't want to create a record that would divulge that in the event of a request to inspect, or just by embodiment in the meetings. So 1051H1 talks about licensing. And what does the legislature intend that these discussions in public proceedings can happen? Meetings pertaining to the issuance, suspension, renewal, or revocation of a license, except that a hearing at which evidence is offered or rebutted shall be open. So the thing that most immediately comes to mind when I think about this exception is public licensure boards. I know we have some people from the boards of barbers and cosmetologists here, so this is something that directly applies to them. They have authority to issue licenses to engage in this particular profession, and they also have authority to suspend, renew, or revoke those licenses. So this exception will apply to things like that. But you'll notice the second clause there of that exception, that the hearing, usually before you can revoke or suspend a license, there's an opportunity for due process. And in that due process requirement under the Uniform Licensing Act is this opportunity for a trial type hearing where the respondent has an ability to rebut any evidence against their license. So those proceedings, the hearing where that evidence is offered, are open to the public. But the meetings where the hearing has occurred, the record has been created, the board has now retreated into an executive session to discuss that record and decide whether the suspension, renewal, or revocation will or will not occur, those discussions can occur in the closed session. You'll note there, I always like to add this, all final actions on the issuance, suspension, renewal, or revocation of a license shall be taken in an open meeting. You'll see this recurrent throughout the Open Meetings Act. You can discuss these issues But when you're going to take action, you have to come back out into the open meeting and take the action there in full view of the public. The second one, limited personnel matters, and this is my least favorite one because this is the one that I often have to have uncomfortable conversations and write determination letters, finding violations, because it's so complicated, and I can see why people have difficulty understanding it. But so I like to take my time and go through it slowly, because you'll notice it doesn't say personnel matters. It says limited personnel matters. So it's a very small subset of personnel matters that you can discuss in a closed meeting. And the legislature tells us exactly what those are. It says the discussion of hiring, promotion, demotion, dismissal, assignment, or resignation of, or the investigation or consideration of complaints or charges against any individual public employee. So before I can properly invoke this exception, I need to have a particular individual employee, not employees collectively, not all my employees. One employee that I'm thinking about hiring, firing, demoting, dismissing, assigning their resignation, or investigation or consideration of complaints against that individual employee. So there's those two prongs, an individual employee and one of these authorized actions. So would it be proper to say, we're going to go into executive session to discuss public employee policy, because that governs every public employee. That this exception wouldn't apply to that. It has to be one individual employee, unauthorized action. Did you have a question?
Yes, going back to the agenda, when you have an issue that you need to put on the agenda to go behind closed doors in executive session, do you have to be specific on what the limited personnel matter is?
Yes, and I'll get to that. I'm going to walk you through how to actually close an open meeting, and you'll see there are two requirements that you have to fulfill before you can do that, and reasonable specificity as to the discussion is one of them. All right, and again, you'll notice here, final actions on personnel not exempt from being taken at open meetings. You have to have your discussions, and then you come back out into the open meeting and take the action. We're gonna hire you. That's done in an open meeting. We're going to fire you. That's done in an open meeting. One consideration under this exception is that the aggrieved public employee may demand a public hearing. So you can exercise this exception, but the minute the public employee says, no, I want a public airing of these actions that are being contemplated against me, then this exception isn't applicable anymore. You have to have it in an open meeting. And judicial candidates also have the right to demand an open interview for appointment. All right, the third one, 1051H3, are administrative adjudicatory proceedings. And those are deliberations by a public body in connection with an administrative adjudicatory proceeding. That's what the exception authorizes closed discussions for. But what is an administrative adjudicatory proceeding? And the legislature defines that as well. A proceeding brought by or against a person before a public body in which individual legal rights, duties, or privileges are required by law to be determined by the public body after an opportunity for a trial type hearing. Very similarly to what I was describing earlier with the boards of barbers and cosmetologists. The person has a right to licensure to practice their profession in the state, but before the body can restrict that right, they have to allow this hearing process where evidence is offered. So where the public body has authority to exercise its administrative adjudicatory proceedings, those deliberations can be held in public, but again, guess what? The decision, the actual action about what decision to make about those individual legal rights have to be in an open meeting. What about 1051H4? Personally identifiable information. And this goes back to what Mona was talking about earlier this morning, the FERPA. There is a federal law that says information about individual students is confidential. So the Open Meetings Act, this is an accommodation of those federal confidentiality concerns. And so they tell us that the discussion of personally identifiable information about any individual student, unless the student or the student's parents or guardian requests otherwise. So this is, to me, is probably going to apply more to school boards, university governing bodies, etc., where the discussion in an open meeting act is so detailed that somebody that was attending and listening to that proceeding could say, oh, I know who they're talking about, it's that one student. Federal law doesn't allow for that, so we had to make an exception in the Open Meetings Act to allow those discussions to happen behind closed doors. All right. Collective bargaining strategy 1051H5. Meetings for the discussion of bargaining strategy preliminary to collective bargaining negotiations between the public policy-making body and a bargaining unit representing the employees of that policy-making body. Sometimes public bodies run into trouble with this because they try to employ it when there isn't a collective bargaining body already in place. This exception contemplates the existence of a collective bargaining body for that entity already. So that's one requirement that you'll have to have before you can properly invoke this exception. And what you'll be discussing is, you're discussing your strategy about your negotiations with that collective bargaining unit. So the public body, the governing body is meeting and saying, we're going to have these negotiations with the union, basically. And here's the strategy that we want to undertake. And of course that makes sense. You wouldn't want to have those discussions in an open meeting because then you're divulging your strategy to your opponent, for lack of a better term. So that's the policy behind that exception. And it also authorizes private discussion of collective bargaining sessions at which the policymaking body and representatives of the collective bargaining unit are present. So the actual negotiations, where they're hammering out the deals on the contract, those can take place in a closed meeting as well. All right, how about 1051H6, certain purchases exceeding $2,500. So the legislature says that that portion of meetings at which the decision concerning purchases in an amount exceeding $2,500 that can be made only from one source is discussed. So you basically have to have a sole source contract being contemplated, and it's over $2,500. Those are very straightforward exception. But also added to that is that portion of meetings at which the contents of competitive sealed proposals solicited pursuant to the procurement code are discussed during the contract negotiation process. So when you open those solicited bids, they're confidential up to the point of the making of the award. So this allows the public body to actually have discussions about whether to select that vendor as the responsible bidder that's selected. And guess what? We see this recurring language again. The actual approval of purchase of the item or final action regarding the selection of a contractor shall be made in an open meeting. So we see discussions in closed session, action in the open.
Louise, is that particular element often embedded in a contract? The requirement?
It's in the procurement code, actually, where you can't disclose the contents of a competitive sealed bid until the point where the selection committee has determined who the successful bidder is. And at that point, it becomes public. And that makes sense because you don't want to negate the state's negotiation powers to get the best and final offer or to sweeten the pot before proceeding further. So this is a regular offender also, I like to call it, the pending or threatened litigation exception. This gets misused fairly frequently, so I like to spend particular attention on this. It's 1051H7. Meetings subject to the attorney-client privilege pertaining to threatened or pending litigation in which the public body is or may become a participant. This exception is predicated entirely on the existence of pending litigation or a credible threat of litigation. Not, I don't want to have this discussion in public because it's really sensitive, and if we take this action, we might get sued. That's not going to meet the requirements. However, if you're in a public meeting and contemplating a certain action, and somebody stands up and says, public body, if you do this, I am going to sue you. That's probably a credible threat, and you might be able to invoke the exception at that point. But before that, it would be premature to do it. Or if there's already a litigation in process in the courts and you can cite to a case number, that's going to get you further to properly invoking the exception. Now, the other thing that this exception contemplates is the participation by a very important person. Who would that be? Yeah, it's the public body's attorney. Meetings subject to the attorney-client privilege. So there has to be some communication between the public body and its attorney. It doesn't necessarily have to be, I'm in the meeting in the executive session with you. That's ideal, admittedly. But it could be, I've written a letter, I'm providing my legal advice to the public body, and the public body retreats into executive session to read this letter and discuss it amongst themselves and decide what course of action they're going to take. But there needs to be some role by the attorney before this exception can be properly invoked. All right. Purchase, acquisition, or disposal of real property / water rights, 1015(1)H. The legislature will also let you go into a closed meeting for meetings for the discussion of the purchase. So if you're going to buy, acquire, that could be a donation. You're going to come into, you're going to acquire some ownership interest in a particular piece of property or water rights, or selling those water rights or disposing of them. Those can be discussed in a closed session. And that makes sense also because you're contemplating purchasing, so there's going to be discussion about getting the best value or the most bang for your buck. So you don't necessarily want to have those discussions in public because then the owner or the potential buyer is going to know what your strategy is and your reasoning and what funds you might have available for that purchase and use it to better their own interests. This allows the state, when acting as a collective body, or the public when acting as a collective body, to reserve some bargaining power. All right. Strategic and long-range business plans, trade secrets. This one sounds really juicy and tempting to employ, but if we delve down deeper into the weeds, we'll see that it's probably not available in most circumstances. Is there anyone from a public hospital here? No? So I don't think it'll apply to anybody in this room. Those portions of meetings of committees or boards of public hospitals where strategic and long-range business plans or trade secrets are discussed. So very, very limited. I told you I wouldn't talk about gaming control board because we don't have anyone from here, but only they have the authority to exercise that. So now I want to get to how do you properly close a meeting. And there are two ways that you can do this. It's all spelled out in 1015(1)I. And the two ways that you can do this are you can have a meeting that's open to the public and you close a portion of that meeting to the public where only members of the public body are able to participate. And then you come back out and take whatever action that you're going to do. That's usually how it plays out. But there is another option available. You can have a meeting that's entirely closed to the public. But remember what I said earlier. Even where you're having a meeting that's closed to the public, you're always going to have to provide what? Notice to the public. So that's the very critical first element before you can do that. So 1015(1)I(1) talks about closing part of an open meeting. And there are certain steps you need to take before you can actually go into that closed session. And the first one is you have to have a majority vote of a quorum of the body. So there has to be a motion to close the meeting. A member of the public body has to actually move to kick the public out of the open meeting, essentially. And that can only be done by a majority vote. And the motion calling for that vote on closure must state the legal authority for the closed meeting with reasonable specificity. So let's say we want to go into a closed meeting to talk about pending or threatened litigation. So I'm a member of the public body. I'm going to stand up and say, I move to close this meeting pursuant to 1015(1)H7. That's the legal authority authorizing those discussions. And I very highly encourage you when you're making these motions to get that specific and say 1015(1)H7 because then it's bulletproof. You have that clear authority. You've cited to it. You're going to ward off any complaints that you're going into open meeting improperly. The second element of the motion that has to be contained is this description with reasonable specificity as to the subject to be discussed. So if we're using the pending or threatened litigation example, my motion will be, I move to close this meeting to the public pursuant to NMSA 1978, 1015-1H7 to discuss, if it's already pending litigation, you just state the case number and you provided reasonable specificity to the public about what you're going to the closed meeting to discuss. Or if you don't, if it's pending litigation, saying pending litigation pursuant to whatever the issue is. It doesn't have to be overly descriptive, but it has to give the public a reasonable degree of certainty about what you're going into the closed meeting to discuss. So you have those two things, the legal authority and a description of what you're going to talk about. And then so you've made the motion and has those two requirements, then you have to take a vote. But that vote can't be in the closed meeting. The vote has to happen in the open meeting so that every member of the public that's in attendance can see how every one of you voted, whether to kick them out of the meeting or not. And additionally, the vote of each member on the motion for closure must be recorded in the minutes. So again, no secret ballots. You have to put it in your minutes, pragmatically by a roll call vote. And you identify each member voted aye to go into executive session or nay to go into executive session, and that's recorded in the minutes. So you see this very exacting requirement for public scrutiny about how the public body goes into the meeting. And then this is very, very important, and I know it's easy to sort of get off track in the executive session, but especially for any of you lawyers who advise public bodies out there, I view my main role in the executive session, if I'm not giving legal advice pursuant to the attorney-client exception rule, is I'm policing them, saying you told the public that we were going into executive session under this legal authority to discuss this specific item. Any discussion outside of that is not authorized. Those discussions have to happen in the public. So you have to keep a real close eye on where the discussion is moving so that you don't have an open meetings violation on your hands. All right, so we'll talk about the second way to have a closed meeting, and that's governed under 1015-1I2, holding a separate closed meeting. This is a meeting where the public never has an opportunity to attend and listen, but they do have that right to know that you're meeting in a closed session to discuss certain items. So, as I was saying, the closed meeting may not be held until public notice appropriate under the circumstance. What is appropriate under the circumstance? That depends, whatever your open meetings resolution says. So if you're going to have a regular meeting and your open meetings resolution says that you have to give 10 days notice and post it at 3 locations in the community before you can have that meeting, then that's what you'll do. You'll give that notice 10 days in advance and you'll post it in those 3 locations. That will vary depending on what your open meetings resolution says, but you need to follow it just as exactly as you would noticing an open meeting. So a closed meeting may not be held until public notice appropriate under the circumstances is given to members of the body and general public. The notice must state the legal authority for the closed meeting with reasonable specificity, and it must state the subjects to be discussed with reasonable specificity. So see, it mirrors exactly the information contained in the motion to close an open meeting. It's the same things that you'll put in the notice. But because you're never in an open meeting, you don't have that opportunity for a motion that will be recorded in the minutes. You have to do that by virtue of posting a public notice that has that information. And this is my personal pet peeve, 1015-1J. And I'll just warn you, if I get complaints from any of your public bodies, this is the first thing I'm going to look at, because for some reason it just drives me insane that public bodies forget to do this. And I've actually, with my clients, scripted out what they say when they come out of executive session to make sure that we don't have an automatic Open Meetings Act violation on your hands. But I can see why people view it as not important, but it is spelled out exactly in the Open Meetings Act, so you want to make sure that you don't get into trouble with it as well. And this requires some follow-up after you come out of your executive session. And I'd like to think of this as sort of the legislature's policing mechanism to keep public bodies on the up and up and cognizant of their very important responsibility to have discussions in public sessions regularly and only limit closed discussions to those 10 limited items. And so what the legislature says is that if you have part of an open meeting that was closed, so you had that motion, you went into executive session, and then you're coming back out to take action on those discussions, the minutes for that meeting, which will be approved at the next meeting, have to have a statement that the matters discussed in the closed meeting were limited only to those specified in the motion for closure. So what you have here is the public body coming back and saying, yeah, we kicked you out of the meeting, but we just want to reassure you that we only talked about what we had the legal authority to talk about and what we told you we were going to talk about. So it's keeping them honest. And the requirement to put them in the minutes has this effect of, if you're a public body, if you're a member of the public body and you went into the closed session and you know that you talked about other things, or you didn't have the authority to go into the executive session to do that, can you in good faith vote to approve those minutes when it has this statement in there saying that we only talked about the things that we could talk about or we had legal authority to do? So you want to, if you're a member of the public body, you want to be really conscious about this provision in your minutes when you're voting on approval, amendment, or disapproval of the minutes. If it has something that's not true, what kind of liability or risk are you putting yourself at by adopting a document that has a misstatement of fact in it? So obviously the statement has to be approved by the public body as part of the minutes under 1051G. And just a helpful hint, I found this to be helpful. I mentioned that I scripted my public body's immersion from, or emergence from executive session to just say this on the record when they come out of there. Because then it makes it easier for whoever's transcribing your minutes, if they hear it in the recording of the minutes, to remember, oh, I need to put that 1051J statement in the minutes. So that's how I like to handle it. It's not required under the Open Meetings Act, but something that I found a helpful tool to do. And then if you had a meeting that was entirely closed to the public, you won't be coming back out to take action, but your minutes of the next open meeting have to have that same statement, that the matters discussed in the entirely closed meeting. We met on such and such date in a closed meeting pursuant to 1051H7 to discuss district court case number, whatever it was, and that's all we talked about are in the minutes of the next public meeting. And the same points with that I made about this statement upon emergence from the closed session apply to that as well. So I want to talk a little bit about Open Meetings Act enforcement, and this is governed under 1015(1)(3)(b). The Attorney General has statewide jurisdiction for Open Meetings Act concerns. So that means if we believe that a public body has violated the Open Meetings Act, we can go to district court in that county and sue the public body and to require them to follow the Open Meetings Act. Part of our authority, as Mona alluded to, also we view as this responsibility to go out into communities and provide education so that we can preempt any potential violations before it even becomes a concern and give you the tools and resources necessary to meet your requirements as a public official under the public body. So that's part of what we view as our jurisdiction and why we're here today. The district attorneys also have jurisdiction to bring those same sorts of actions that the Attorney General can, but only in the county of jurisdiction. So we can go wherever in the state, but the district attorneys only have recourse to the district courts in their county. And the Open Meetings Act carries with it this concept of a private attorney general. And basically, they can bring a suit against a public body to compel enforcement of the Open Meetings Act as well, but they carry with them some additional requirements before they can bring those suits. And the first thing is they have to provide written notice to the public body, 15 days notice. So the public body has conducted a meeting that the person thinks has been a violation of the Open Meetings Act. They have to first write a letter to the public body and say, on such and such date, you did X, Y, and Z, and I think that's a violation of the Open Meetings Act. Before that private person can bring suit, they have to give that notice and then allow the public body 15 days to cure it. And what does a cure entail? Basically, if the public body agrees that a violation may have occurred, they call a special meeting, essentially, and they summarize the proceedings or whatever was discussed in the portion of the meeting that was deemed to have been a violation. and then retake whatever action was taken. So you basically put back out there the discussions that should have been public back out into the public forum. And you do that and you retake the action, and it's as if the violation never occurred. That's what the Open Meetings Act contemplates as a cure for the violation. So that is an option for you public bodies. It might be easier to deal with going back and calling a special meeting and just retaking the action rather than having to deal with the litigation as it progresses. So keep that in mind. But if the public body disagrees with the person that there's been a violation, and they've done nothing to cure the violation within the 15 days, at that point the private attorney general can go to district court and sue for enforcement of the OMA. Now, what are the consequences of violating the OMA? And sometimes there's an attitude out there that OMA, it's nice and all, and this concept of greatest possible information to the public is all well and good, but it's just a hindrance on us doing the very important work that we've been elected or appointed to do. It's not that simple. There are some very serious consequences to violating the act. The first one is if in that litigation, in that suit, you're deemed to have violated the Open Meetings Act, it's as if the action you took in that meeting never happened. That can be really important. What if you had a major contract on the line that you approved on that, and non-compliance with that contract is going to result in some very serious financial consequences to your public body that has dollar signs attached to it. And if you had just followed the Open Meetings Act as it's spelled out, you wouldn't have to deal with those potential consequences. Another consequence is the court can issue injunction, mandamus, or other appropriate orders to enforce the OMA. Can make you go back and do it over, force you to do something, say you didn't comply with the Open Meetings Act. And if you're a public official, how beneficial to your reputation or your stature in the community is it going to be to have a court order saying that you violated a very important public act? So some very personal consequences too that you want to keep in mind before just blatantly disregarding the Open Meetings Act, or maybe not so blatantly, maybe inadvertently. 1015(3)(a) and C say that the court must award costs, reasonable attorney's fees to a successful complainant. So that private attorney general who sued, guess what? They're going to go hire the best attorney in the state at the highest billing hour rates. And when the court tells you that, yep, you sure enough violated the Open Meetings Act, and guess what? You got to pay that lawyer's bills, which could be tens of thousands of dollars. And all of these funds come out of your public budget. How is that going to reflect on your reputation or your effectiveness as a public official?
I have a question, and it doesn't come up often. So, obviously, there's times that people bring suits against the public body and they lose. Mm-hmm. In those instances, can the public body go after?
No.
For court costs and fees?
Only if it's frivolous, and that's a higher standard. Just because you lost, I mean, it could be a really close case, and I'm dealing with this issue in a litigation in the First Judicial District also. The complaint that was submitted to the Attorney General's office on its face looks like it had merit, but it wasn't until we actually delved into the facts that we could reach a determination as to whether there was a violation or not. That's not frivolous, where it could or could not be a violation. Frivolous is only where there's no way, there's no circumstance that this could be a violation of the Open Meetings Act, and only then can the public body recoup its attorney's fees. It can get, what does it say? If the public body prevails, the court must award costs. So the public body will get its costs, but can only award attorney's fees if action was brought without sufficient information and belief that good grounds supported the action. So it's limited for public bodies. They're not going to get, whereas if you're found to be in violation, the court must award your attorney's fees to the private attorney general. Only to the attorney's fees to the public body only if it was frivolous, basically. All right, and as I was alluding to earlier, unlike IPRA, OMA carries with it criminal penalties, and that's under section 1015(4). Any person violating OMA is guilty of a misdemeanor, and upon conviction, subject to punishment by a fine of up to $500 for each offense. In my memory, I can recall an instance where the Attorney General's office enforced an action against a public body for violations of the Open Meetings Act and did get a conviction. So now these people have a criminal record for violating the Open Meetings Act. And as a former colleague of mine used to like to tell audiences, I don't know about you, but if I'm going to have a criminal record, I want it to be for something really sexy and not a violation of the Open Meetings Act. I tend to agree with that. It's sort of nerdy to have an old violation on your record sheet, but I don't know. I guess it's up to you. So where are we on time? Okay, we've got a few more, 15 minutes. So I want to give you these little bits of takeaway tidbits. And these are things that are more nuanced situations that aren't explicitly described but implied in the Open Meetings Act, in the text of the Open Meetings Act. And the first one is this, and this actually is described in the Open Meetings Act, delegated authority. Can anyone think of an example where this might come into play? Where I see it a lot is use of committees, subcommittees, to exercise the public body's work. So you can't, the Open Meetings Act says the public body has some authority to take whatever action it can be. It can't delegate its authority to one person or a subcommittee for the purpose of circumventing the requirements of the Open Meetings Act. Now, there's nothing wrong with using subcommittees, but you have to be very careful about what those subcommittees do, because if it's a subcommittee that simply gathers information, doesn't limit the options available to the public body, doesn't bind it to some particular course of action, that's just what we call an advisory committee. And they're not exercising any of the public body's authority. They're just providing information providing function. And the public body is still open, available to take whatever course of action it wants in a public meeting. Those subcommittees are not going to be subject to the Open Meetings Act. But where you have a subcommittee that's taking action on behalf of that public body, even if it's less than a quorum of the public body and would be subject to the Open Meetings Act, it's going to carry with it the responsibilities under the Open Meetings Act too. So take a very close look at what your subcommittee is doing. If it's taking options off the table, we've got 5 applicants for a job and we're eliminating 3 and giving only 2 options to the public body to decide who to hire. You've eliminated that options and you've bound the committee to only those two options. Guess what? The meetings of that subcommittee are going to be subject to the Open Meetings Act as well, so you need to be very careful with that. The next concept I wanted to talk about was rolling quorum. And does anybody know what this is? It's very common and it's very easy to do, especially in the day and age of email communications. So a rolling quorum is a serial discussions amongst a quorum of the public body outside of an open meeting. You remember we talked that even discussions about public policy by a quorum have to occur in an open meeting. So I'm Commissioner X on the County Commission Board, and you're B and C. And I get this really great idea. And we'll say the County Commission is 5 members. And there's 5 of us, and me, you, and he and you are members of the commission. And I get this great idea that relates to public policy, and it would be super beneficial to the community. And I go to Commissioner B and say, hey, here's this great idea. Here's this policy thing that I think we need to adopt for our community. And don't you think it's great? He and I are having a discussion. A quorum is 3. So it's he and I, 1 and 2 commissioners discussing. That's not a quorum. The Open Meetings Act won't apply then. But when we go, hey, don't you love this idea? Let's go talk to Commissioner C about it. Now A, B, and C are talking outside of an open meeting. That's a quorum. Our discussions relate to public business. Suddenly, we're talking about public business outside of an open meeting, and you've got a violation on your hands. So, especially in small communities, we're not saying that you can't, you're at the grocery store and 2 of your colleagues are in line at the checkout stand, that you have to run away and flee it. You just have to police yourselves and say, oh, we've got a quorum here. We need to be cognizant not to discuss public business. Otherwise, we have to notice the meeting and allow the public access to our discussions.
But that rolling quorum counts even if it's just me and that person talking about what you and I talk about, right?
Yeah, serial discussions. So as long as that discussion stream hits a quorum, 3 people. If we contain it to you and me, and that's not a quorum, and the discussion never goes to any of the other public bodies, we're probably going to be okay. But you know, it's the game of telephone. Then I get on the phone and I say, I talked to so-and-so. Or another tidbit is like email, reply all, instant violation. So what I tell my board administrators is if there's nothing wrong with receiving information and communication from staff. They're not members of the public body, so there's no violation. What can be a violation is when you hit reply all and your fellow commissioners are on that distribution list, and now you have a discussion amongst all of them outside of an open meeting. So what I like to do is when there are these email discussions and there's a potential that there might be responses and getting a rolling forum going, I have the members of the body in the BCC field so that they don't have the option of hitting reply all and having an automatic violation. Sure.
What I do too is if, say for instance, I've got some board members, more than three or more, attending a school law conference coming up at the end of this month. So I go ahead and post a media notice that there will be a quorum of board members attending.
That's super conservative, and I applaud that. I think that's the safest course to do. And then, I mean, you said that, especially if you're in a community outside of Albuquerque, you published a notice that they're going to be meeting in Albuquerque. No one's going to drive to Albuquerque just to listen to any discussions that they may have. But you've met your requirement. We may have this meeting. You can attend and listen. If you want to drive to Albuquerque and sit in and follow them around, I guess you can do that. The other thing you can do that's maybe not so extreme is, like I said, there's nothing wrong with having a quorum in the same room. The problem arises when you start discussing public business. So if you're going to have these meetings or retreats or whatever, you may not even need to notice them, but what you need to do is police yourselves and say, there's a quorum of us here. We can't talk about public business unless we've noticed it like you have. All right. Executive sessions, taking action versus information gathering, investigation, and advice. This is basically just reiterating, you always take the action in the open meeting, the discussions take place. That's where you deliberate, that's where you receive information. You have discussions amongst yourselves about how to proceed, but you always go into the open meeting to take the action. One of the reasons I bring this up is because there have been instances where public bodies think that they need to take some sort of vote in the open meeting, and you want to be careful not to do that. I know of instances where people are, keeping a tally sheet of how many votes, and that may or may not be a violation, but I'd encourage you not to do those things because the intent is for you to come out and have a vote in the public meeting. So be wary of those sorts of things. Executive session pending threat and litigation. I already talked about this. There has to be credible threat or already existing litigation. Also this idea that the exception doesn't exist simply for the rendering of legal advice, especially for public lawyers. This is a really important consideration. There is no exception for having meetings to talk to your lawyer about whatever issue it is. It has to be tied to pending or threatened litigation. So to the extent that you're rendering advice in a public meeting or the public body asks you for your advice in a public meeting, that's on the record, and that's going to be, available to anyone in the minutes in a request for minutes. So where their information is sensitive and it is properly under the attorney-client privilege, what you want to think about is using memos or telephone calls or things that you can properly withhold from inspection if you don't want that advice being disseminated publicly. But you need to take care to that you can't just go into an open meeting to give your client legal advice, into a closed meeting to give your client legal advice. And the last thing I want to talk about is obligations of public bodies under OM. We talked a little bit about this concept of our goal under the Open Meetings Act is giving the public the greatest possible information and allowing them the greatest opportunity to attend and listen. So this requires some forethought and anticipation by public bodies. If you know you have a really contentious item on your agenda and the community is going to turn out in droves to listen and attend and probably comment, maybe angrily, it's probably wise to schedule a venue that's going to be able to accommodate, because if you keep it in your normal room that only seats 5, Are you allowing them the opportunity to attend and listen? And if you're not going to move it, what about broadcasting? The right is to attend and listen. So what about having an overflow room where you have a webcam set up and you just have a direct feed that people can go in and sit and attend and see and hear what the deliberations have been? That's a creative way to ensure compliance with the OMA without maybe having to take expensive or unnecessary steps. Again, OMA represents the floor and not the ceiling. It's really important to keep that consideration of greatest possible information. What are the things that we can do to give information to the public? We might not be required to, but in fulfilling the spirit of the OMA, how far can we go? How far should we go? Should our position be we want to be as 5 minutes, okay, as restrictive as possible, or do we want to be as open as possible? And always having that dialogue internally amongst yourselves. How much information should we be giving? And maintaining the integrity of the official record, which are the minutes, is an important consideration. I've had some experience where staff took it upon themselves to alter minutes, and it's the public body's responsibility to keep minutes and designate those records their official ones. So it's not appropriate for staff members or anybody who's not a quorum of the public body to make changes to minutes. It happens sometimes, so the public body wants to be cognizant of those and making sure that the minutes that are in place accurately reflect what the board has decided is the record of that meeting. And so I'll take any questions now. I think you had your hand up first.
A lot of these intricacies seem to be decided by the entity or the department. Is it required to have a written policy that addresses these issues?
Other than the Open Meetings Act resolution, there's not a requirement. I mean, obviously you'd be subject to what the Open Meetings Act says. That applies also. But there's no requirement that you actually have a policy that spells out what action you take in any given instance. But to that extent, if you don't have one, we're available always to answer questions about how you can proceed with your meeting in full compliance with the Open Meetings Act also. Do you have a question also?
The part about reasonable notice, so they have resolution, is that subject to the place where you make that determination? Is that subject to?
Yeah, you have to. That's a requirement that I didn't mention. When you adopt your open meeting resolution, that has to be in an open meeting also. So the public has access to that decision about what the reasonable notice is.
Okay. The Mutual Domestic Water Consumers Association. Sometimes they're privately owned, but they're still subject to the Open Meetings Act.
And that's because they're designated as political subdivisions in the state and statute. Yeah. And I think we're back here, and I'll get to you.
Is an Open Meeting Act violation can be against a specific individual, or is it always against a local body, an entity?
Well, only a body can have a violation because they can only, by action of a quorum, can do it. So I wouldn't anticipate there being an action just against an individual. It would have to be against the public body. Would you agree with that, Mona?
Yeah.
Okay.
Right, it's only public body.
Yeah. And then you had a question?
In reference to school boards, they are required to comply with the Meetings Act.
Yes, school board.
Don't they get a violation?
They can get a violation. I should mention also that there is a presumption in the Open Meetings Act that a public body has complied with the Open Meetings Act. So it basically becomes incumbent upon the person that's alleging a violation to prove it, essentially. But yes, school boards are subject to the Open Meetings Act because they're political subdivisions of the state also.
Going further, aren't school boards required to advertise for superintendents, or can they just appoint?
Depends on, I don't know what the law says.
I'm not sure either. It depends on where that authority is vested. You said superintendents? The school board's hiring a superintendent?
Yes.
I think, I'm just guessing here, I think that authority lies in the school board, so that if that's an action that they're taking, they would have to do that in an open meeting, but I'm not 100%.
Seems like they always advertise. and you have some kind of discipline and so forth. And recently, I've seen in different school districts, oh, somebody was fired today, they already have a board. Let me call your office and maybe get some.
Sure. And my contact information is in one of the last slides on the PowerPoint printouts that I gave you, so feel free to call me, and my email's on there as well.
So with Board of Nursing, we have several committees, subcommittees, 2 committees, and so some of our members are all over the United States. And so when you talk about the board, it's going to form. Now, the executive director, we appoint what we call nurse educators just in the local program. We sometimes put out their resume and their credentials to the committee to give us response and feedback if they think that this is a good position to appoint. If we ask them for not like approval, but we ask them for feedback to appoint, and then we actually give the letter to appoint them, not the committee.
If the communications are limited to the board member and the staff person, and it's a two-way communication, and there's no involvement by other members of the public body, you're probably okay. What you want to avoid is this attempt to sort of poll the members to determine consensus before, because that probably is an open meeting violation. So if you're going to be having communications limited to that one board member, I want your feedback. What do you think about this? I'm a staff member, you're a public body, you're a member of the body. There's nothing wrong with that. But when it starts going, okay, I talked to you, now I'm going to this other commissioner and saying such and so thinks this about this applicant, and then going to another one and saying so and so thinks about this, you're contributing to that discussion outside of an open meeting. So I'd be careful about that. Yeah. Are we out of time? I can take questions afterwards for a little bit, yeah. But thank you for your attention. I hope it was helpful.